Yes.
Thank you. So, good afternoon, everyone. I would like to extend a warm welcome to all of you who have just joined us today for this roundtable discussion on detention conditions in France and in other countries. Your participation is highly appreciated, and it's great to see you here. The purpose of this roundtable is to delve into the topic of detention conditions, not only in France, but also in various other countries. Our goal is to foster a deeper understanding of the challenges and best practices in this area. And in this sense, we encourage an open and informed dialogue where each of you can share your knowledge and experiences, and where we can collectively explore potential avenues for collaboration. So we encourage you to actively participate, to ask questions, and to share your insights on this topic. Now I'd like to hand over the floor to my colleague, Theodor Burnar, who will guide you through the agenda for today's roundtable. Theodor?
Thank you, Adelina. Welcome to everyone. It's good to see you again at the second event of the WOLEP Criminal Law Practice. Our previous introductory meeting took place in the summer, as you may recall, on precisely 20th of June. Obviously, our network has made progress over the past few months, and so did the criminal law practice. We currently have, and we are proud to share this info with you. We currently have 4 active legal practices in the WOLEP network, namely the real estate law practice, the corporate law practice, the sports law practice, and the obviously the present one, the criminal law practice. The last of our practices, the corporate law practice, was established last month, and we had a chance before this meeting started to talk about this development, of which we are proud. Also, I would like to inform you, as is customary at our meetings, that another development in our communication activities is the fact that we are producing a second episode of our legal podcast, the WOLEP podcast, and its topic is legal ethics in the digital age. I hope this is a subject that makes you curious. So I would like to encourage you as lawyers to participate and to express your interest in this second episode of our podcast. It will give you a chance to talk about your practice, but also to increase your visibility within the network, but also towards the general public, towards customers, towards clients. So that would be my brief update on the network's activities. And moving on to today's topic, I would like to introduce our host for today, Mr. Nicolas Richardoz. He's a brilliant young lawyer in Bordeaux, France. He has studied in both France, his home country, and Canada. And he has a keen interest in criminology, amongst other domains. I will quote Nicolas when saying that he considers fighting spirit as one of his biggest assets. He is one of the founding members of the WOLEP Criminal Law Practice, as you recall. And I will use another quote from a WOLEP talk that we had together. I think it was last year, Nicolas. Nicolas told me that when he was very young, he had a lot of difficulty accepting injustice. And I think this is very valuable and speaks volumes about his ethic and his passion for criminal law. So without further ado, ladies and gentlemen, I give you Mr. Nicolas Richardoz.
Thank you, Theodor. Hi, everyone. Well, it's a pleasure and an honor to introduce the second roundtable of criminal law. The topic, I mean, there are many reasons why we could talk about conditions of detention, but before we dig into the subject, please feel free to interrupt at any time, of course. It's better when we can discuss everyone, and if everyone can share its experience, it will be even better for everyone. So do not hesitate if you have something to bring to the discussion. It would be a pleasure. Why talking about the condition of detention? Well, we have many actuality dealing with the topics. For example, France has been condemned 18 times since 3 years by the European Court of Human Rights. So it's actually an issue in France. I also had a personal experience at the court because I think I talked about it at the last roundtable. I was defending a Bulgarian citizen, and at the end of the trial, the judge asked my client if he's to be convicted and condemned to prison, would he prefer to be imprisoned in France or in Bulgaria? And I thought to myself, I have no idea what I could advise him if the condition of detention are better in France or in Bulgaria. What are the differences? If the civil rights are more respected in France or in Bulgaria. So that's why I had this idea of discussing the topic with you today. And also the third point is maybe more obvious, but as lawyers, it's our role to fight injustice and to make sure the civil rights of our clients are being respected. So those civil rights, what are they? I mean, we have in Europe, especially, we have a global guideline, which is the European Convention on Human Rights. And regarding the conditions of detention, there are a few articles which are very important and which we have to think about when dealing with our clients, of course, when we defend our clients and when we leave the case with them. The first one and the main one maybe is the third article, which prohibits the slavery and forced labor. It might be obvious, but in detention, some people are sometimes confronted with a situation of sometimes torture or at least inhuman treatments. And it's our role to ask clients if the detention is going well and if their rights are being respected. It also seems obvious, but sometimes people don't really know their civil rights, and they don't know if it's normal that they are being treated the way they are. And especially after long-term detention, for example, people don't really know anymore the barrier or the border between a normal treatment and what abnormal treatment is. So this is the main one, and on this article, it's usually this one which is used by lawyers to have countries convicted when they don't respect the civil rights. The second article, it's the number 4. It's also interesting because in detention, in France, but I guess it's the same in other countries, people are able to work in detention. But talking about France situation, people can't work for free. And even when people are being convicted to general interest work, which is working for free for the state, they need to agree with it. So as lawyers, it's also our role to make sure that people are not being treated as slaves, or they can work in a normal situation. And if I can recall some English class from high school, I remember that in the United States, the situation is a bit different, and the minimum salary for inmates is very low compared to the one we have in Europe. But if we have people from the United States, maybe they will be able to talk about it. So yeah. The other article, which is in my opinion very important, it's of course the right to liberty and security. You might think why the right of liberty has to deal with the detention, because when you're detained, you're not free, of course, but as you may know, the detention is an exception to liberty, and it's an exception that needs to be strictly framed by a legislation, national-wide and European-wide, I would say, in the case of European countries. So it's also very important to make sure as lawyers that the people, our clients, are being detained for a good reason, and that the procedure has been respected when people are being detained. The next article from the European text, it's also the right to a fair trial. It's also very important, I think, because you have many declinations from this article. You have the fact that people, when they go to court to be judged, they need to be, in my opinion, in a good shape. I have seen many times clients being detained for 4 days in police custody, and then showing to the court without being showered and without having clean clothes. And then you have to defend yourself after 4 days of I don't know how to say, but maybe like you're being in a cell, a dirty cell without sleeping properly, and it's difficult as a citizen to present yourself in a good way and to be defended. I mean, to be judged in fair conditions. The other aspect to me, which is important, is the fact that sometimes people are being detained during a few months before they are judged. It's called in French instruction. I don't know if you guys have the same in Europe, or somewhere else, but it's the case when people are being arrested and then they are either detained or being under how to say, judicial control, so that the authorities can do the investigation, and it could take a long time, and sometimes it takes a few years, 3 to 4, 5 years in the biggest criminal cases. And to me, it's difficult to have a fair trial when you judge people sometimes 5 years later, 6 years later, and it's difficult to judge a situation which is very old when you judge it now. I mean, I know that there was a case, it was not criminal case, but it was a construction issue about something, construction in a court in Paris. And the case has been judged 17 years after the facts. And finally, a judge said nothing happened during so long times, and so the case was dismissed. Which is also important, and a thing to remember when defending our clients. The last article I would like to talk about is, of course, the respect to private and family life. In detention, the family life is also, of course, a big issue. I don't know how it works elsewhere, but in France, in short period detention centers, people can only visit their family in a small room with windows, so you have no intimity. It's of course difficult for them to have a love relationship and intimity with their wives, children. And it's also difficult to have privacy in the cells because especially due to overcrowding, there are sometimes 2 to 3 and even sometimes 4 people in a cell, and it's difficult to have a kind of a private life in those conditions. In the detention centers for longer terms, we now have sometimes some family rooms which allow a little bit of privacy, but it's still an issue that we need to remember. there are also many issues with the exercising the civil rights when being detained. I wrote down marriage, vote, and religion. Of course, it's difficult to get married when in prison. It can maybe sound stupid, but I have a client in detention who wants to get married, and he's not able to go to the notary to sign the papers. So there are some very concrete and practical issues when being detained that causes problem to exercising your civil rights. I think now religion is being dealt properly. I mean, more properly than it was before, but it's still difficult to vote. And for example, in France, the rate of vote from inmates, I mean, the inmates who are allowed to vote, the abstention, I think, Theodore, it's abstention.
Yes, it's okay, abstention.
Abstention, yes. Yeah. So the rate of abstention in prison is way higher than in a normal society. So those civil rights are also an issue when being in detention. And that's why it was important to me to discuss about it. Now, Theodore, you had a question to introduce to our members that they can vote about, and we will discuss about it, and it will be interesting to discuss about the answers at the end of the roundtable.
Thank you. In order to make this meeting a bit more dynamic, we thought about doing a little poll in which to see your opinions about the topic at hand. Therefore, I would like to share something with you. If Nicolas can turn your presentation for a bit. Thank you. Okay, great. So I wanted to share with you, just a second, a little poll that I designed. Yes, just a minute, please. For those of you who can do it, I can also send it via chat. So I will send you also via chat a link where you can vote. What I will be also projecting a QR code. If it will allow me to do it. I don't know why, but it wouldn't allow me for the moment. So as you can see, we have a question for you. Okay. So I will be sharing my desktop. You can also scan the QR code. And by doing that, you will be able to see our question. Whatever option is best for you, you can do it. So our question was related to which aspect of detention conditions do you believe should be prioritized for improvement across countries? And you have the option to select more variants if you want, more options. You are not limited to a single response. So we listed access to healthcare and mental health support, adequate nutrition and basic living conditions, recreational and educational activities, fair and timely legal proceedings, because Nicolas has told us that delays are a very big problem for clients, for inmates. Also, protection against torture, abuse, and excessive use of force, because as we all know, and we've seen many examples, police brutality is a very important topic. And also reintegration programs aimed at reducing recidivism rates, because once someone is behind bars, recidivism becomes a problem and they get out. So this was my brief interlude. Thank you, Nicolas, and I will now stop the sharing. We are very anxious to hear about your opinions once the presentation ends, and we'll check the results. Thank you.
Thank you, Theodore. I'll just try to share again.
And sorry, Nicolas, until you resume your presentation, I would also like to welcome Mr. Giancarlo Paolo Pezzuti from Italy. Good to have you.
Yes, you hear me?
Ciao.
We can
Okay.
hear you, but we can't see you.
Okay. Moment.
Good to have you with us. I'm sure your insights regarding the Italian criminal law system will be very, very significant. Thank you, Nicolas.
You're welcome, Theodore. So for the one who are joining us lately, I was talking about the main articles from the European Convention on Human Rights, which deal with detention, of course. And I was going to move to the reasons why people are being detained in France. I framed the discussion about people over 18 years old, which is the majority in France. So we have different types of detention in France. We have, of course, police custody. It could be you and me or anyone who is being arrested by the police for any reason, good or bad. Of course, police custody is framed by durations, maximum durations. We can't be detained forever, of course, and also the legal articles who frame the duration of detention are also coming from the articles we talked before from the European Convention on Human Rights. We also have the pre-trial detention, which is when people are being arrested, presented to a DA, prosecutor, and then they can't be judged straight away. Sometimes an expertise needs to be done. Sometimes the court is not able to judge right away. And then people are being detained for a duration until the court is ready to judge them. I gave you the durations for French law. It's in correctional. It's not the major offenses, but up to 10 years. It could be 4 months, and for criminal law, the detention could be 6 months, renewable 3 times. But sometimes it's being a much longer period, depending on the case. Then moving about, I think I missed a page, sorry. Yeah, here. In order to be detained for pretrial detention, there are many reasons that the judge needs to point out to justify the detention, because as I said before, the detention is an exception to freedom, and then the judge has to justify means after means why he puts your client in prison. In France, there are then 7 motives, which are listed at Article 144 of the procedural code. And sometimes, from my experience, I see judges who use sometimes 4 or 5 motives without really any reason. They just, sometimes you even think they paste and copy the decision from one to another. And I feel like they don't really think about why they put people in prison. And it's our role to force the judge to justify why they put your client in prison. And the reason have to be really obvious. For example, when you have a judge, it can happen. And when you have, for example, a client who hits somebody with his car, not voluntarily, and they will give you as a motive, put an end to the offense or prevent its recurrence. I mean, it's not an intentional infraction. I don't see how my client would do that again. He's already in shock. you have no change, he does it again soon. So the motive is not very obvious and it's not really justified. And sometimes, to my opinion, it's even useful to appeal the decision, even if the client stays in detention, but to force the judge to justify its decision and put the person for the good reason in detention. It's also very difficult for a client to be detained when they don't understand why. And it's even more difficult for us as criminal lawyers to explain them why they are in prison when the judgment is not really justified. So those motives are strictly framed, but it's our role as a guardian of our client's right to fight when the decisions are not really really clear and applied. Then the detention. We have, of course, different types of detention. As I said before, the short-term detention, people are being detained in some, it's called maison d'arrêt, which is like a house of arrest, I would say. It's a prison where you have people being detained for short periods, so they have always some turnover, people coming in, people coming out. And it's the kind of prison that are the most overcrowded. And so the people who are staying for a short period are usually the one who endure difficult conditions of detention. We'll talk about it a bit later, but you have a lot of overcrowding. The hygiene is terrible, and also it's very noisy, and the buildings are in terrible aspect. In long-term detention, comparatively, you have, I think it's the same in many countries, the biggest criminals, sometimes who are very famous, they usually stay in a long-term detention center, which has much more comfort and which are less overcrowded. So it's a bit antinomic, because the people who are being detained for short periods, and so who did the less, the smallest infractions are being detained in the worst conditions. So it's also, it's also our role to make sure the people are being detained in relatively normal conditions, and we'll talk about it later, to help our client to adjust the sentence. In France, the main adjustment to sentence is listed on the right side of your screen. We have of course, the ankle bracelet. You have also the day release, which means people stay in prison at night, and during the day they are able to work or going to school or to follow a formation. And it's, of course, a big help for reinsertion because people are trying to go back to a normal life. And you have also sometimes the placement outside this institution, which is more for people with social difficulties. So it's not a prison, but it's a specialized place where they are able to have more educators helping them, for example, or some doctors helping them for special health issues. It's very important as criminal lawyers to try to have a sentence adjustment, of course, because our client have, it's maybe obvious, but they are more able to start a normal life and not do some criminal activity when they are able to progressively go back to the society. And so our role, to me, is mostly to discuss with the family, to have contact with the family and sometimes the wife, the sister, in order to justify to the judge the possibility for a monitoring bracelet or a day release with, for example, housing bills to show that people have a house, people have a job, and it's very important in order also to diminish the overcrowding and also to help our clients to go back to a normal life. And then we have also a point which is very important to me regarding detention is the treatment of mental health. In France, we have an article which means that when people are not in capacity of knowing what they did, they are declared irresponsible for their crime. So they can't be declared guilty, and they are only civilly responsible, which means they can't be detained in a normal prison, and they are not declared guilty. They can just assume financially what they did when needed. You have also an article which means that people have diminished capacity, which means they are still responsible for their crimes, but the sanction will be adapted to their situation. It's usually the case when people have psychiatric issues, but they are still knowing what they did, but the diminished capacity makes that they will have a different sanction than a normal person. So it's sometimes our role also as lawyer to ask for expertise, to ask for counter expertise sometimes when the first one is not satisfying, in order to defend our client as best and to help them have a sanction which is adapted to their situation. Hold on, I think. No, here we go. Sorry, I have a problem with my mouse. Here we go. Yeah. So I already talked a little bit about the different types of detention. We have, of course, the remand centers and detention centers, which are for long-term and short-term period. Sometimes you have also isolation rooms, which is for very difficult clients, the type of people who are dangerous for themselves or for others. In France, I don't know in your countries, but in France, we don't have a huge role in choosing where the client goes. It's mostly the detention administration with the doctors who chooses where the clients go. But sometimes when people are being placed too long in isolation, for example, the role of lawyers can be to denounce the situation. We'll talk about it a little bit later with a famous French case. We also have in France the disciplinary quarters, which is when people do something in prison, for example, insulting the guardians or fighting with other inmates. They are being placed in disciplinary quarters. And there is also a disciplinary procedure inside the prison to judge the infraction being committed in prison. Personally, I did not defend the client yet being convicted for disciplinary issues, but I know there are many cases in Bordeaux and elsewhere about discipline issues. But what I can say is that disciplinary issues is more frequent when the conditions of detention are being worse. It's maybe obvious, but of course, when people are 3 or 4 in a cell, you have much more risk of having disputes between inmates than when they have their single bed and single cell. Finally, the last type of detention is called specialized medical unit. It's a type of detention center which is adapted for people with medical issues. For example, I have a client which has been convicted for, I mean, not condemned, but who has been placed into custody for assassination. He was, first of all, in a short-term detention center. And I think it was 3 weeks ago when I went to the detention center, they told me, no, he's not there anymore. He has been placed in a specialized medical unit because there was a risk of suicide. And so it's the role of the administration and doctors to discuss where the people have to be placed. And sometimes it's even a better solution because in Bordeaux, the specialized medical unit, people have their own cells. It's very quiet. It's really new. The building is 20 years old. Compared to the normal detention centers, which is going to be destroyed next year, it's really overcrowded. You have, I think it's 150% occupation rate, which is a lot. It's one of the worst in France. So sometimes it's even better for the client to be placed in a specialized medical unit. First, you have less risk that people kill themselves, and also the comfort, the daily comfort is much better. Then let's talk about the life in prison, except if some people wants to say something or share an experience, maybe. Feel free, you do not hesitate.
Later.
Later?
When you finish, I prefer at the end.
Okay, no problem. The life in prison, as I said before, the inmates are able to work for a salary which is less than the minimum salary in a normal society, but they are still able to work to make a little bit of money to pay their minimum comfort. There are also activities, of course, but it's difficult for some inmates because they sometimes have to wait to be on a waiting list for a few weeks or months, and it's sometimes difficult for them to participate effectively. But in my opinion, it's very important to encourage our clients to participate in those activities. First of all, it makes the daily life a little bit nicer, maybe, and it gives them occupation. But most of all, it gives the opportunity to your client to show the judge, the application sentence judge, I would say, I don't know how it's called in English, but the judge who is going to allow people to be free before the date. It will help the client to show the judge he's behaving well in prison. And it's also our role to, of course, encourage client to show the nicer way of their behavior. Then a little bit of statistics. I don't know in other countries, but in France, the situation is pretty delicate. You have, as I said before, you have an occupancy rate of 120%, but the most important number is the 144.5%, which means that people are very currently 3 or 4 in a cell. In France, cells have 2 beds only. So you have sometimes a mattress on the floor and sometimes 2 mattresses or no mattress, which means people sleep and live in terrible conditions, which creates, of course, difficulties between inmates and also between inmates and with the guardians, which are, of course, dealing with the lack of means in prison, and which creates difficulties. Those difficulties, of course, are probably the same in many prisons around the world. I talked before about overcrowding. The thing Lockstop, it was an operation we had in Bordeaux last May and June. The prison was so much overcrowded that the administration from the prison decided to refuse any new inmates in prison, which means our client, instead of being transferred to the prison near Bordeaux, they were transferred to a prison 200 kilometers away from Bordeaux, because the prison didn't accept any other prisoners, because the situation was going very even dangerous. There was some guardians who were on medical stop. They were stopped by the doctors because they were not able to work properly, which means the other guardians had to work instead of them. So I don't know if it's clear. I see Theodore's face. But
No. Actually, thank you, Nicolas. I was thinking about because there's a big discussion here in Romania about the amount of money that the state spends on an inmate. And I was wondering if you know from statistics, from official statistics, how many euros does the French state spend for the accommodation of inmates?
I have no idea. But what I can tell is that the budget for justice is one of the lowest in Europe. But for inmates especially,
now I see Giancarlo smiling when you said that.
We can't hear you, Giancarlo. The microphone is closed.
I was telling that maybe the lowest rate is a Ministry of Justice in Italy. I don't know in France exactly, but even in Italy, the investment in justice are very low. But the price has, if we say the price for every inmate is calculated to the salary of the jail guards. So it is not a real statistics, because you have to put not only the jail, the facility of the jail, the food, but even the salary of the special police for the jail. So it is not a real investment for the inmate. The inmate it doesn't have any money, but all the structure can be very expensive in a country or lower in another country.
Thank you, Giancarlo. So yeah, I was saying that the detention had many issues. Yeah, the overcrowding. I was talking about the lock stop operation last June in Bordeaux. Of course, the detention creates isolation. People are being separated from families and from society. That's why it's very important to me to create links between inside and outside, especially with helping people to have readapted sanction, for example, the bracelet again. We also had an issue, I talked before, the dilapidated buildings. In Bordeaux, the prison is going to be destroyed and a new one is being constructed. But even with the new building, which will be available maybe in 2 years, the new building will already be too small for the people, the number of inmates we have in Bordeaux right now. So it's a never-ending issue.
Sorry to interrupt you, Nicolas, but you are
Yeah.
very famous at destroying prisons, you know, from
France?
Bastille, yeah.
Yeah, I can imagine, because when you have a shift in governments, they always make a new prison operation and they create new buildings. And then after 30, 40 years, you need to do something again. The prisons which are being destroyed right now are the ones who were constructed under Mitterrand in the 80s. So, but they are always too small. And even if you have a bigger enough prison, it's difficult to have enough people to work in it, because the conditions of the prison guardians are very difficult. The salary are low. And of course, I don't know if you guys would love to work in a prison, but it's kind of a difficult job to do every day. So yeah, there are many, of course, many issues with detention, which create, of course, anxiety, stress, and those effects are not only for inmates, but also for the guardians who live there, because the more stress and anxiety you have, the more issues you have. And when you have issues, when you have anxiety, the inmates are going to insult or aggress the guardians, which are going to be on medical stop, and then it will be even more difficult for the one staying at their job to do their job properly. So it's a never-ending cycle, I would say. Then we have a few examples of detention conditions. The first one was for, I chose Romania, of course, because we have many people from Romania in WOLEP. The Romania has been convicted because there was not enough hygiene in the detention centers. And then the Romania was condemned by the European Court in violation of the Article 3, which we talked about before. And what is interesting is that the European jurisdiction gives measures to implement the condition of detention, like an advice, like your old auntie who gives you advice. And then it would be interesting to see if Romania actually heard the advice and put into concrete measures the advice given by the court, which were reducing overcrowding, of course, and preventing remedy and specific compensatory remedy. The other one I talked before shortly was a famous case in France, in which actually France wasn't convicted. It was Mr. Ramirez Sanchez, which was known as Carlos. He was an extreme left or communist, maybe, terrorist. And this guy was detained in isolation for 8 or 7 years, which means he was in a single cell alone for 7 years. And even the 1 hour walking, which is allowed in France every day, he was alone. So it means that during 7 years, this guy didn't talk to anybody except his lawyers and maybe the 1 or 2 guardians who gave him the food. It's very interesting there because I can imagine that Mr. Ramirez Sanchez lawyers raised the issues in front of the French court and then the European court, which means that as lawyers, we can have a role in denouncing the issues with detention, which is here is isolation, but it could be anything else. I would imagine the most general situation would be maybe the inhuman treatment and the hygiene in detention, which is probably the most used case the clients could meet. So this is very interesting because I mean in this case France wasn't convicted because of the special aspect of the person, which was a terrorist, but in other situations, if he wasn't a terrorist and if he was not a very dangerous person, maybe the lawyers would have be given reason by the European court. I think we are almost at the end of my presentation. No, we have a few more slides. In Europe, we have the International Observatory of Prison, and in France, we have the General Controller of Places of Deprivation of Liberty. It's 2 institutions who have a role in making sure that the conditions of detention are being normal and that the rights of inmates are being respected. We have, even inmates can contact those organizations when they are living some not abnormal situation. What can I say? In France, there was a few police custody in Brittany, which is northwest of France, the region facing England, where there was police custody with very dirty rooms. Even the toilets were unable to be used. And so there was a few lawyers and a controller from one of those institutions who controlled it and who denounced it. And sometimes the role of lawyers and also those organizations can help to denounce situation. And sometimes when the state doesn't do anything when it's being forced, denouncing the situation in the media can also be helpful, even if even if the observatory and those institutions have no real power of sanction. This being said, our role, of course, yeah, it's approximately what I just said, but our role as lawyers, of course, is to defend our clients, and we are the first one who are able to show or to denounce a situation when the conditions of detention of our clients are not being respected. And that's why it's very important to be able to raise those issues when meeting. That being said, I'm not sure I can give the right advice to my Bulgarian client. I don't know if there are people from Bulgaria here, but I would be curious, of course, to know your position about how the conditions of detention are in your countries and what are the main issues you meet. So thank you for your attention. And I'm curious also to see the result of the vote.
Thank you so much, Nicolas. Let's give him a round of applause for the very insightful presentation. And I can help you with the results of the poll. They are pretty interesting, and I would like to invite you to discuss them together. Let me share my screen. So I hope you can see the access to healthcare and mental health support seems to be the most important for our poll respondents. So close to 30%. They also chose protection against torture. They saw it as very important, against abuse and excessive use of force, and coming on in the third position, adequate nutrition and basic living conditions. At the other end, recreational and educational activities seem to be less important for those who answered the poll. What do you make of it, Nicolas, Giancarlo, Angela?
Well, maybe Giancarlo, you want to speak, but I was going to say, I am even surprised that recreational and educational activities are only had one vote. Two things. First, because the voters had the choice to put any choice they want, and also because it's not dealing with the civil rights properly. I mean, when people are not able to have educational activity or recreational activity, it's not a violation of their rights, but it's still their daily life and comfort which is in play.
I think the colleagues that voted, who voted, prioritized, the most stringent, the most urgent matters, and
yeah, maybe.
Somewhat, yeah, recreational and educational activities seem to be, the less urgent ones.
If I can say something, I like to say, well, the theater is right. All of these are big problems in the Montenegro, but the healthcare is a big problem. Not so for the addicts, because they have some physiologically healthcare there. But I think that physiologically care is not so good. Protection against torture, yes, in detention, police detention, it's problem in our country and all countries on the Balkan, because our laws are very similar, usually the same. About activities, recreational activities, where we have some programs in projects in some last years, and they have some activities there, but that it is individually because they will not allow to do some activities in the prison or detention to dangerous criminals, or only where some less dangerous, because we have some criminals that are very dangerous in detention, because in Montenegro we have two very famous criminal groups that are against each other, and because of that that people from each other of the criminal groups they will not mix up, because they make problems in the prison and in detention also. And because of that, I voted the most for the healthcare and for the for the protection against torture, abuse, and something like that. This theme is so long, and I can talk about this hours and hours. And the conditions in our prisons are very bad. Not for the people that serving penalties, prison penalties, but for the people in detention are very bad conditions. And our prison building for our prison are very small for so many people. And for example, you have four or five people in the same room that are in detention. That's so many people in the same room that are small. But we have only two prisons in the Montenegro, that is in Podgorica, in the capital of the Montenegro, and in Bijelo Polje. But all people that are put in the detention, mostly they are in the Podgorica, and that is the problem all of this. But they are talking about making other building in other cities, but that is all in the talks in the future, not activities about it.
Thank you, Angela. That's a very good insight on the situation in the Balkans. I think it's representative for how things stand in this region. What about Italy, Giancarlo, if you can illuminate us? Because I know that you've also written academic papers about this problem.
Your microphone is still off, Giancarlo.
We can hear you. If you can unmute yourself, please. I think you can also press the space bar when you talk. It's the simplest way.
You hear me?
Yes.
Yes. Sorry, I confess I just voted to the poll. I think the most important and the less investment are in the reintegration programs aimed at reducing recidivism rates. This is you know that the constitution in Italy put the aim of the punishment that should be the to re-educate the inmate, but there is no program, there is no support for the families, and there is no program to educate or re-educate and support from a social point of view, or for any support for the inmates. So there is great rate of recidivism when someone declared guilty go in jail. Is much more. That's why in Italy in the last 10 years reforms, if there is a short-term punishment, there are many alternative measures to avoid that inmates and guilty people go to jail, because everybody knows that if you enter an Italian jail, you get out worse than you came in. So for the short term, for the punishment lower than 4 years, there are many alternatives. You can apply for you can find a job proposal with the social workers, and for 4 years you have this kind of surveillance by the justice system, and you don't spend no one day inside the jail. And this is the only way to avoid the risk of recidivism. But I want to add something that I confirmed my participation at this seminar 2 weeks ago when I received the invitation. But just 3 days ago, I started to learn something about the French procedure, because I was involved in a case involving Italy and French justice. So I want to take advantage of 1 minute to ask to our colleague if there is, because I read quickly in the last 3 days criminal procedure books, criminal procedure, something I found on internet. Is true, did I understand right, that the final punishment can be fractionate in if the final punishment, for example, is 8 years, the judge can decide to execute 4 years and suspend the other 4, or I'm wrong about that?
No, it's true. I don't have the exact English translation, but for example, you can be convicted to 8 years in prison, but a part of it will be called sursis, which is a few years, which you don't do if you don't commit another offense in a certain time.
Okay, and this is in the final judgment of all, is something that is something granted to the inmate when he already in jail. Is the judge when he declare the final judgment, or is something that depends on the behavior inside the jail?
No, it's something that can be granted by the judge, but sometimes you have the simple sursis. I don't know if it's, which is if you don't do anything in usually it's 5 years. You don't do this part, the non-executable part, but most of the time you have this part is associated with obligations, which is going to work or following information, pointing to the police office, avoiding contact with the victim, etc.
But there is no limit. I mean, I can suspend all the entire judgment.
Yeah. It can be fully sursis, like non-executable, or partly non-executable. But you can't have, for example, for a murder, you can't have 12 years of prison plus 4 years. It's most of the time for the short detention. Short-term
The
detention.
shorter, there is a limit.
Yeah, I don't remember if it's 5 years maybe or something like that, but
okay.
You can't have it for a very dramatical infraction, for crimes like that. And it's also our role as lawyers to militate for this type of sanction, because we ask for people to have a part in prison and then a part outside prison, but with obligation. In front of the judge, we ask to have no dry way out. With dry way out is when the person leaves the prison from like Monday he's in prison, Tuesday he's free, and he has no helps and no social social help to reintegrate the society. So sometimes we ask for a part with sursis. I don't know how to say that.
Okay, thank you.
Anyone else maybe wants to share?
I have a question on your first outline when you show the cases of the temporary detention.
Yeah.
I didn't understand. One of the option was to protect the person under investigation. I don't understand. To protect the suspicious.
Yeah. Maybe you want me to put it back on the screen. Hold on. But yeah,
to protect from the family of the victim.
Yeah, the first one is preserve the evidence or material clues necessary for it. Like it's like preserving the proof. The second one is prevent pressure on witnesses or victim as well as on their family. So I think this one makes sense. The third one, protect the person and their investigation. Yeah, it's the fourth one. It means that sometimes somebody has committed a crime, and if he stays free, he risks vengeance from people. That's sometimes happening. Yeah, I can imagine in Italy you have the issue with mafia.
Yes, I have a case. I had a case. Well, it was not a mafia case, but it was a guy who he was a very good behavior during his long 10 years detention, but the judge didn't give him he has the right to have a discount over 3 years, but the judge didn't give, despite he has a good behavior, because there was a risk that the family, because he killed a guy. And so there was the risk that but sooner or later he should go. So I went to Supreme Court and I did all my best, but they didn't give him this discount because there was this risk.
There was a risk and they didn't want to take it.
I know now he's free. Now he's free. He changed city, but I think that he could do the same even if the judge gave him this kind of discount.
Yeah, that's interesting.
I have to say that said the colleague Giancarlo, it's same to us in the Montenegro. Some clients they don't give them discount because of the case or because of that kind of the criminal acts that they are accused. For example, I had a client that she accused for the trafficking people and women. And because of that, that was so much in media, and that kind of the criminal acts are very, as I say, popular because so much criminal acts were in Montenegro, and because of that kind of the criminal acts, she didn't get discount of the penalty. Beside that the law, according to the law, she had right for that, but no, the court decision, it's not was like that. She has to be in the prison for whole duration of their penalty.
Interesting.
As a colleague, as a colleague said, Giancarlo, I do all of that I have and can do, but no, it's not. They are not interested about that for her, and she behaving very good in the prison, but no. They are talking. We don't want to make decision about it at all. Don't interesting at all.
Thank you so much, Angela. If I am allowed a question, Nicolas,
Yeah.
we're talking about the somewhat difficult and meager conditions in most of the prisons in France. Yeah, I think it applies to the whole of Europe. And I was wondering, because we've had a few cases, notable cases of high-profile inmates in Romania who, when they entered prison, so they were convicted, they entered prison, and because they had a lot of money, they adapted their cells. They had internet, they had TV, they were like at home, they were like in a hotel. They couldn't leave the hotel, but otherwise they renovated the prison in which they stayed. Sometimes there were, news in the media that some of them even received a segment of the prison just for them and their friends. They even had bodyguards. So I was reading about Carlos Ghosn, the famous former CEO of Renault.
Renault, yeah.
I think he's an international fugitive now. He was last time in Lebanon, I think.
In Lebanon, yes.
And I was wondering if, I don't know, at some point he's returned to France to serve his time. Do you think he would get the same conditions and the same treatment as a normal inmate, or would he receive preferential treatment? I mean, this is a hypothetical scenario, but I think the same applies to an Italian case or a Balkan case, a Montenegrin case, for a high-profile person, a former, let's say, mayor or politician or businessman. I mean, there is this common perception that there are two judicial systems, the one for people who have money and influence and the one for normal people who still maybe 10 euros and maybe get a 5-year sentence and are then treated to the conditions that you described. So what do you think?
Well, it's a good question. There was a concrete example a few years ago in France. We had the mayor from a big city nearby Paris, which was convicted for corruption, and he was placed into custody in one of Paris prison. But it was told that he was. I mean, there was not maybe bodyguards and etc., but he had one of the best cells, and he was able to have a visit. And the conditions of detention of this guy was quite different to our clients in Bordeaux or elsewhere. And that was actually, people had to knew about it, and there was a kind of a scandal because people said there is two different type of justice. But it's a special case because it was the first time in France that somebody was being detained for corruption. Because most of the time people don't do prison in France for white collar crimes.
Yes, we know all about Nicolas Sarkozy, for example.
Yeah, and I think there was one director of the Bayern Munich football club that was convicted and who served, I think, a year or two in prison a few years ago. And at the time, people in France said, "Oh, we should have the same in France." But culturally, people in France don't do jail time for white collar crimes.
Merci beaucoup pour
Mais de rien.
réponse.
So if you would be convicted to prison, Theodore, where would you go?
Well, I think I would stay in Romania. I tend to think that the Romanian legal system is improving all the time. I'm an optimist by nature, so I wouldn't want to go abroad.
All right.
But knock wood, I hope I don't get in that situation. But anyways, if I do get, I have some pretty good criminal lawyers here.
So we're going to say that you have many Romanian lawyers who can help.
I count on your help. Thank you. Great. So if someone has another question for our speaker today, because from what I've seen, the conversation has been very lively. And it's very interesting to compare the situations. Mm-hmm. You would say that it doesn't differ too much from country to country?
I guess especially in Europe, because we have the same legal system, I mean, coming from the European Convention. But I don't know if there was somebody from the United States. No? In the meeting?
No, I have some experience for United States, and I can referring to what Theodore Todd twice. The first when he talked that in Romanian people is complaining about the investment on jail, and the second when he was talking about the special facilities that in some jails there are. And this is what is happening in the United States. In some states, to save money, because people doesn't want to spend money, public money, for the inmates, for the guilty, for the bad people, is much more frequent that in some states, some jail are built by private companies. So the public money are saved, and the private can invest. Even from a marketing point of view, they say, we put the bad people in jail so you can buy our products. So it is a double there is a double result, that the people is happy because the state doesn't spend money, and from the second hand, the company make marketing on the guilty, on the murderer. And some people can choose. It's like resort. There are some jail very, very beautiful. They can choose, I want to go to that jail or the other jail. And this is a typical American system that I hope, I prefer that in Europe the public money will build the jail, if it is necessary to build the jail. Because as I told you, especially in the center Europe, maybe in the northern, I don't know if there is someone from Sweden or Norway, maybe in the northern Europe, the programs to re-educate inmates are much better than southern and central Europe. So maybe in that culture is better to have places to re-educate inmates. But in the center of Europe, we are very far from this result. So I prefer to anyway to that public money will invest into jail if this is necessary.
That reminds me actually of some English class in university when we studied the United States prison system. And if I can recall, the private prison, or I mean the prison who are administrated by private company, they put inmates to work. And if I can recall, it was maybe a few cents per hour, which is almost like slavery, maybe. And that makes me think about the article I talked before, which is the respect of slavery. I mean, no slavery and no forced labor. And so it means that if I'm right and if my memory is good, it means that those companies make profit on behalf of inmates, which allows the state to spend less and also to make money because they have less regulation about inmates' job, which is way different than European system, fortunately.
Another thing that I was wondering, Nicolas and Giancarlo and Angela, and of course our colleagues attending, would be, do you see in the future a change in the mindset of judges, because you have all these advancements in artificial intelligence, you have all types of alternatives, methods to monitor the convicted fellows. So maybe that's a solution to the overcrowding in prisons. You know, you have all these performant surveillance cameras that can trace them. So do you see any advancements in this regard?
I don't know. I think that in the Canada and in the United States, the artificial intelligence are already implemented into the civil matters for car accident or condominium cases. I hope that I will never see artificial intelligence in the criminal cases, because it will be I think a disaster. About the surveillance on on jail and inmates. Our colleague Richardoz already told us about the systems that can be activated to check the people that are not into jail, but they are in alternative facilities. Of course, these can be useful, but this is not artificial intelligence. Artificial intelligence for me is something very, very risky for in the legal system. This is my opinion. I check some. I don't remember now. I didn't download any software, but I just checked the artificial. There is a artificial by Google. It's free.
ChatGPT maybe?
Google Bard.
Bard, yeah.
Yes, Google Bard. I put my name just to check. I put my name, and he talks. Okay, Giancarlo Pezzuti is a criminal lawyer in Italy, blah blah, and then he wrote something total fantasy. He wrote some cases that I never deal with. He like this 20 lines of totally invented stuff. I don't know how people can trust on this system. Maybe Google is still a experimental software, but I'm afraid that we are, and I hope that we are very far to have this artificial governance, because of course if we have artificial intelligence into legal system, we will have artificial intelligence into surgery and any other cases of life. And for me, my skin is freezing if I, because it's something that we saw many times in the movie, and I don't want to act into this movie. Maybe our sons, our grandsons, maybe, I don't know.
Well, Theodore, to answer your question, first of all, I put my name into ChatGPT, and ChatGPT told me I was a professional snowboarder from Switzerland in the 90s. So I don't think we can trust fully the program. But in my opinion, ChatGPT, or I mean the intelligence, the AI could be used not to, in my opinion, not to help the judge to make the decision, but more like as a tool to write down the decision and to deal with the administration work, but not in the judging process. For example, personally, I had this client from the United States, and the convention, I mean, the contract between me and her was in French, of course, but in order to inform her of the details of the contract, I put the contract in ChatGPT. I asked ChatGPT to translate in English, and in 10 seconds, I had the contract in English. I checked it, and it was actually quite correct. And even the presentation was the same as the French version. So it's a great tool to inform your clients, for example, in this case, or to find some, for example, for translation is great. And I'm pretty sure later it could be used by the court and administration in order to deal with the large amount of cases. But the judge is not going, in my opinion, to use the intelligence to make the decision. Another thing, in prison, I don't think we could have effectively the intelligence dealing directly with prisoners, because as we talked before the meeting, when we talked about the lockdown during COVID, what emerged from the COVID lockdown is that people need human contact. And it's very difficult to have human contact if a screen is giving an order to an inmate to go from room A to room B. So even with the intelligence and computers, you can't replace human contact. That's why it will be still the human activity before ChatGPT overcomes us, I would say.
Thank you so much, Nicolas and Giancarlo. I think that's a very good conclusion to our conversation today. And I have to say, Nicolas, that I changed my mind regarding your question. So if I did prison time, I think I would choose the island of Capri near Naples. So yeah, to sum up, I think this discussion today was very appealing and provocative. And I will hand over to Adelina for the concluding remarks. Thank you.
Thank you, everyone.
Thank you, Saudat. First of all, I'd like to thank and congratulate Nicolas for this comprehensive and informative presentation. I believe we learned a great deal about detention conditions in France. And I'd also like to thank Angela and Giancarlo for sharing their perspectives with us on this topic. Your insights have been invaluable. As we move forward, we encourage you to continue sharing your expertise and ideas within the Criminal Law Practice group on WhatsApp. So please don't hesitate to come forward with new and interesting topics in the field of criminal law for our upcoming roundtable. Thank you.
Thank you.
Thank you. See you next time.
Ciao.
Bye. Thank you for attending.
Bye-bye. Thanks.
Thank you. Bye.
Bye.
Bye bye.